Good morning, everybody. Can you hear me? Make sure my mic is on. Okay, great. Delighted to be here. Thank you for the committee for inviting me and the Texas A&M AgriLife Extension for sponsoring this. I usually speak on this topic to students or lawyers, and I think this is a much better crowd because you all are a lot more attentive. You're dealing with your own property and you're spending your own money. And so I see a lot of people taking notes, which I don't typically see very often. My topic is an update of the comparative Texas and Oklahoma oil and gas conservation laws. The word comparative implies some type of a valuation or picking winners and losers. And I assure you that while this Saturday I will be in crimson and cream in Dallas, and I will be rooting for Oklahoma to win, I do not have a dog in this fight. I'm going to try to be as fair and equal as possible in comparing these two areas of law. All right, so what are conservation laws? Conservation are the laws enacted by the state regulations and statutes to regulate the density of drilling, the location of wells, and it's done in three primary ways: unitization, spacing or well density orders, and then pooling. Why are there conservation laws? Well, primarily it's to prevent waste, to avoid the drilling of unnecessary wells, to avoid damaging the reservoir because of inefficient drilling activities and methods, and then in association with that, to maximize the recovery of oil and gas. Another equally important reason for conservation laws is to protect the correlative rights of all individuals. That's the term used in the Oklahoma statutes. Texas uses a slightly different word, although I would say probably has a little different meaning, and that is to prevent confiscation of oil and gas rights. And then finally, an incidental benefit is it is used to hold acreage, maximize the amount of leasehold that can be held with a single well, and to promote the development of the resource. Prior to the enactment of conservation laws, which in most states occurred in the early 1930s, this is how we basically drill for oil and gas. Basically, the rule of capture: if your neighbor drilled a well, you quickly drill the well as close as possible to that well. It was a closeology idea, and it resulted in very wasteful drilling, waste of money, drilling wells that didn't need to be drilled, and then draining the reservoir in an inefficient manner, which minimizes the recovery. So why are these laws relevant to landmen and people in this community? Well, the unit size and shape establishes the boundaries of the mineral ownership that shares in production in a well. Unitization causes the dilution and the proration of revenue ownership. So it establishes what lands are going to be allocated to a well, and then it establishes what revenue is going to be distributed. And then ultimately, with respect to working interest, it determines who is going to share in the cost and risk of that expensive operation. For people who are confused about these terms, pooling, unitization, spacing, they're used interchangeably a lot of times, but from a strict legal, at least regulatory standpoint, unitization typically refers to a field-wide or a larger operation that includes previously drilled wells, such as a secondary or tertiary recovery unit, where you're trying to maximize recovery from existing wells. Spacing typically refers to the creation of a drilling unit, proration unit, or governmental spacing unit, which just establishes the boundaries in which a single well is going to be allocated. And then pooling, although you have pooling clauses, which in effect are the same as spacing, pooling in its strictest sense is the means by which you share in the cost and risk of drilling a well. So that would focus on the working interest or the cost bearing, as opposed to spacing, which focuses on the royalty and the revenue distribution function. Okay, absent conservation laws and to try to avoid the problem of the rule of capture, most oil and gas leases starting in the 1930s adopted typical pooling clauses that allowed the operator to pool the lands with other interest in those lands or other lands to form units. And once those units are formed, the royalty is distributed proportionally based on the percentage of that lease or that tract bears to the total unit. Prior to the enaction of conservation laws, the only real regulation on the size and shape of those units was an implied duty to pool in good faith. So it would be inappropriate to pool, say, 10,000 acres for a single well, even though early leases might allow that because they didn't have caps or restrictions on that. So the implied duty limited the size and shape to the lands that can be reasonably drained by a single well. State spacing and pooling law statutes were enacted, and then they, in addition to more sophisticated leases, expanded upon the voluntary pooling idea. This is just a plat to show you that you could have multiple units covering the same land. That in the yellow would be, for instance, a 160-acre oil unit, and then the whole 640 represents a gas unit with a horizontal wellbore, and those bars along the wellbore represent perforation points. So, and I'll get to later, this would be an example of concurrent development of vertical and horizontal wells. Okay, I'm going to talk about the specific statutes, try to go through them as quickly as possible, both in Oklahoma and Texas. Then I'm going to give some illustrative examples of things that I think are interesting as applied to these laws. And then lastly, I'm going to just kind of give a quick summary of the specific differences in the two states in various areas that we've talked about. This is the Oklahoma statute, 52 OS 87.1, that establishes the jurisdiction of the Oklahoma Corporation Commission to regulate well spacing when to do otherwise would constitute waste or drainage not compensated by counter drainage. And here's the statute that allows them to establish units. The Corporation Commission, upon proper application, has the power to establish well spacing and drilling units of specified and approximately uniform shape and size. That's an important point, because when I get to that comparison, the key in Oklahoma is these units are of approximately uniform shape and size. So you're going to have primarily rectangular or square units in Oklahoma. The spacing requirements in Oklahoma are provided by rule, and depending on the size of the unit, that dictates how far from a lease boundary, or actually from a unit boundary, the wellbore can be. So it ranges from 165 feet from that boundary all the way to 320, depending on the relative size of that unit. And they can range from 10 acres for a shallow oil well to 640 for a gas well. And then, as I'll talk about later, you can even have a 2,560 acre unit for a horizontal well in Oklahoma. Importantly, though, there are no minimum distance restrictions from unleased tracts in Oklahoma. It's a big point in Oklahoma as compared to Texas. Once you've established a drilling and spacing unit in Oklahoma, it is effectively a combining of that land for total uniformity. And if you have an unleased tract or uncommitted tract in that unit, you still have the power to drill across it and to include it in your unit. Okay, you're supposed to have uniform size and shape units. The well bores are supposed to be drilled within a box, depending on the minimum boundary distances, but there is a provision that allows you to have a location exception. If your well bore, if you have some type of a topographic issue or geological anomaly that would cause you not to want to drill on a legal location, you have the ability to go to the commission, file an application, give notice to interested parties, and they can grant a location exception, which will allow you to drill that well closer to the unit boundary. Typically, you'll see, the boundary will be 1,320 feet, and you want to drill as close as 330 feet from a unit boundary. The commission is authorized to do that. Oftentimes, they will adjust your allowable to penalize you for that, because you're going to be draining from your offset unit. but they also will typically grant that offset operator a mirror location so that he can be as close to the boundary as you are. So it doesn't really affect the ultimate production. The other thing that the commission is allowed to do is to provide increased density wells. In theory and in practice, with vertical wells, you're supposed to testify that one well can adequately drain the unit. So you give your testimony at the hearing that from your geology and engineers that I can drill one well in this 640-acre unit and it will drain the entire unit. But after you've drilled the well, if circumstances change based on your knowledge of the production, you have the right to go to the commission and ask for permission to drill additional wells, usually up to three additional wells, one in each quarter section. I can tell you that in Oklahoma, it's very easy to get location exceptions, or to get location exceptions, but to get increased densities. In fact, I've always been confused how you would go to the commission, testify that one well can adequately drain the unit. 2 weeks later, you file an application for 3 increased density wells. Well, how can that be? But the commission is very pro-development, and they typically allow that if offset operators don't complain. Horizontal drilling historically was subject to the same rules. You would drill a horizontal well in a 640-acre unit. You could not drill across the unit boundary in Oklahoma, so all of our horizontal wells would just be, no more than 5,000 feet of lateral. But in the last 7 years, most recently this year, we've adopted new rules and statutes to accommodate long laterals, which I'll talk about in a few minutes. Okay, pooling in Oklahoma. Oklahoma has a unique pooling statute. No other state in the union has one like ours. Arkansas sort of has one similar, but it's limited to unlocatable owners. So according to 52 Oklahoma Statute 87.1E, it states that owners may pool their tracts of land to validly pool and develop their lands as a unit. However, if they have not agreed to do that, upon a proper application and hearing, they can require the owners to pool and develop their lands in the spacing unit as a unit. In order to bring a pooling application, it is a jurisdictional requirement to have a drilling and spacing unit. A lot of times you'll have applications that are spacing and pooling, but the spacing always has to be heard first because you cannot pool unless you have a governmental unit. Notice is really important. I note this case of Optima versus Mewburn. That case involved 2 landmen who had made a side agreement that the Optima was not going to protest the pooling application and supposedly authorized the Mewburn landman to represent that to the administrative law judge. The order was entered, Optima was pooled, turned out to be a good well. And the Optima landman said, I'd never agreed to that. It's a he said, she said, kind of like what we saw last week. And the commission said, well, forced pooling is serious stuff in Oklahoma. It's essentially eminent domain. So we're not going to try to decide who was telling the truth. And the fact that Mewburn did not give notice as required by law meant that basically Optima won that battle and they were able to come in after the fact and make an election. So the commission realizes that they have great power and they tried to make sure that people have the right to be heard. Okay, typical pooling order in Oklahoma provides 3 options. You get the application is heard, testimony is given about the fair market value based on what has been paid to owners for leases in the 9-section area. And the order goes out and it will say what your options are. You can either, you got 20 days to make an election, you get a well proposal, you can either participate by prepaying your well cost, or you can give up your right to participate, effectively leasing, although you don't get a formal lease document, for no cash and a quarter. I've never seen one more than a quarter royalty. And then the third option, which is the default option, if you just don't respond at all, is you get a cash bonus based on the fair market value and a lower royalty, typically an eighth, maybe a little higher. Pooling orders, unlike oil and gas leases, have a shorter term. They are 6 to 12 months. Nowadays, they're almost always 12 months because of the horizontal drilling. And it's important to know that a pooling order, unlike a lease, only covers the zones that have been pooled. So if your oil and gas lease, unless it's zone specific, is going to cover all rights until your Pew clause kicks in. Well, in Oklahoma, you're only going to receive through that pooling the zones that you've actually named. So typically not all the zones. Okay, Texas. Texas regulates well density and spacing a little bit differently. Instead of focusing on the unit first and then determining where you can drill within that unit, they focus on the distances between other wells. You can't drill anywhere closer than 1,200 feet from a well completed in that same zone. And you cannot drill closer than 467 feet from a property division line in which you don't have control. Most horizontal drilling and other types of drilling are covered by field rules. This is the Barnett Shale field rule, although most of the other horizontal rules are similar. That setback is not 467 as provided under the statewide rule. It's actually 330 feet, recognizing that horizontal wells don't drain as far. So if you cannot drill a well without an exception closer than 330 feet from an unleased tract. When you're talking about a horizontal well, that 330-foot boundary is qualified, and that is that it doesn't just go from any point of that wellbore. It goes from the nearest perforation point in that well to your tract, which makes sense. If the wellbore happens to be too close to the boundary, but there's no productive interval of that, it doesn't really matter. So the commission recognizes that you have to be doing it from a perforation point to determine whether that's a legal well. If the operator, when they're getting a permit, realizes that they're not going to be able to meet that requirement, they have an option. They can ask for a Rule 37 exception, and that is to allow them to drill that well, notwithstanding the fact they're going to be too close to a offset well or too close to an unleased tract. In Texas, Rule 37s are taken very seriously. And if you drill a well without having first gotten approval, either through a regular permit or a Rule 37 permit, you're subject to having your well shut in, the allowable withheld, and potentially the death penalty of having to plug your well. So if you're trying to get a Rule 37 exception, the key is who you're going to have to give notice to, and that notice is given to the people within a minimum distance, either half the distance from the prescribed minimum between wells or the minimum lease line spacing distance. And that notice goes to the offset operator. All lessees of record who don't have an offset operator, say to a unit that hasn't been yet drilled, and then all owners of unleased minerals. The burden of proof at a Rule 37 hearing falls on the operator, and it is to determine whether this well is necessary to prevent waste or to prevent confiscation of property. I can tell you in my 20 years in drilling wells in Texas, I never won a contested Rule 37 exception. So, does anybody else in this room ever won a contested Rule 37 exception? No. Okay. So the key is that, let me back up just a minute. The key as a landman and lawyer dealing with these illegal wells, so to speak, or wells that are going to come too close to your boundary, is you don't want to have to give notice to somebody, because if they get notice, they might protest your Rule 37. So the key is when you're setting up your drilling permit, how can you assure that you're not going to affect somebody so that you have to give them notice? And as an example, if you're drilling a horizontal well and your wellbore is likely to come too close to an unleased tract, first thing you do is try really hard to get leased. But if you can't get it leased, then I can tell you from experience in the Barnett Shale, some people don't lease not because they want more money or they want better terms. We're seeing more and more people that just don't want oil and gas drilling. And in Fort Worth, that was a big problem for us. You'd have people who were against drilling from an environmental standpoint. They were against fossil fuels. All legitimate reasons why they might not want a well, none of which the commission really is equipped to deal with. And then another one would be when we're drilling in a subdivision of sometimes $1 million homes, they legitimately didn't want a well bore, in a rig less than 1,000 feet from their property. So what do you do? Well, we had to move our well bore, or we had to make sure that our perforations were not going to get so close. So it affects the economics of your well if potentially 500 feet of lateral has to be condemned because you're that close to somebody's property who, if given notice, is likely to show up. They might even bring the media and make a circus out of your Rule 37 exception because they don't want drilling in their community. So again, when I get to the comparison, you'll see that could never, ever happen in the state of Oklahoma. Okay, well density is similar to increased density in Texas. It's dealt with a rule called Rule 38. And in Texas, your proration is granted based on your allowable is based on your unit size. The minimum unit size in Texas is 40 acres. If you're drilling a horizontal well, you get an additional 20 acres based on the length of lateral. Based on the statewide rule, your field-wide rules are going to be different about that. For horizontal wells, Rule 86 is what governs that, and again, you get your additional 20 acres. With the field rules, though, you're going to be bound by the 330-foot lease line boundary. And interestingly, it's only 100 feet from the toe and the heel, with the understanding that you're not probably draining when you don't have your perforations open laterally. So if you kind of think of a box of what a legal location is, you got 330 feet around the perimeter, the sides, and at the toe and the heel, you can be 100 feet from an unleased line. All right, everybody in Texas seems to think that we don't have forced pooling here. Well, in fact, that's not true. There is a statute on forced pooling, and it looks remarkably like Oklahoma's statute. It provides the authority under the Texas Mineral Interest Owners Pooling Act for the Railroad Commission to establish a unit and pool all the interest in the unit within the area containing the approximate acreage of the unit. And the only restriction on size or shape is it cannot exceed 160 acres for an oil well or 640 acres for a gas well, plus 10% tolerance. So it is a limitation on a horizontal unit because you're only going to be able to pool 640 acres. You might have a 1,500 acre voluntary unit, but your unit, if you can get it formed at the Railroad Commission under this act, is going to be limited to 640 acres maximum. And again, like Oklahoma, if the parties have not come to a voluntary agreement, the commission can require the owners to pool their interest, and the commission will pool the smaller tract with the adjacent acreage on a fair and reasonable basis. They will pool only the acreage which at the time of the order reasonably appears to lie within the productive limits of the reservoir. The jurisdictional requirements are that you have to have given a fair and reasonable offer to the party you're trying to pool, and the order will describe the lands, designate the location of the well, and designate the operator. The people who can be pooled are going to be owners of interest in an existing proration unit, owner of a working interest, or owners of unleased tracts. The commission will dismiss the application if it finds that a fair and reasonable offer to voluntarily pool into the unit has not been made. And the offer has to be on the same yardstick basis as the operator has given to other owners within the unit, and that will be viewed as a fair and reasonable offer. So you would testify the best terms I gave to any unleased mineral owner is $1,000 and a fifth royalty, or I gave them the opportunity to participate, and here's my JOA form. And the statute says that a fair and reasonable offer to pool and to participate can be done with a proposed operating agreement, but oddly, it can't have these four particular things. It can't have a pref right to purchase. It can't have a call on production. It can't include overhead expenses as part of or it can't exclude your district central office expense as a reasonable overhead charge. And you can't prohibit the non-operators from questioning operations. It gets pretty into the weeds here in my view. And it provides that if you give a fair and reasonable offer and your JOA doesn't have these offensive terms in it, then if they elect not to lease, but they also don't want to prepay and participate on a heads-up basis, then the commission can assess a 100% penalty on them to compensate the operator for taking on all the risk. So that would be essentially a 200% back end. To put it in context, states like the Rocky Mountain states typically have a 300% back end penalty for a non-participant under their pooling laws. Louisiana has a 300% non-consent. In Arkansas, when we were drilling in the Fayetteville Shale, for an initial well in the Fayetteville Shale, a non-participant under pooling was subject to a 600% penalty. And for infill wells, it was 400%. So this concept exists throughout the country as far as compensating the operator for advancing the cost of drilling a well. But note, there is no lease option in Texas. They can either lease voluntarily. If they don't, the commission then determines, at least implicitly in this statute, that the only penalty is a risk fee not to exceed 100% of the well cost. I want to talk about one case in particular really quickly. This was the Findlay Resources case. It's been 8 years now or so. It was in the Barnett Shale. It involved a unit that we were trying to drill. The operator was Findlay Resources in a densely populated, lower income housing addition. And despite months and months of leasing door to door, they could not get 28 town lots committed that contained only 5 acres in a 160-acre unit. These were people who, it was unopposed. No one had said they were opposed to drilling, but these were people who were unable to be found, or they just wouldn't answer the door. They were opposed to drilling, or they didn't understand it. A lot of this was generally didn't say in the opinion, but it was a primarily Hispanic neighborhood. They didn't really understand this. They were skeptical of somebody coming to their door and offering them money, and they just wouldn't do it. And so rather than try to get a Rule 37 exception, which would essentially say we've got these tracks in our proposed wellbore that are too close, so we'd like permission, knowing that nobody ever wins a contested Rule 37, they chose instead to try to go the pooling route, to try to pool those tracks into their unit. And they had offered these owners 3 options: to lease the minerals, participate up front, or farm out your interest, essentially a non-consent situation. Findlay testified that they asked for the 100% risk penalty for somebody who didn't want to participate, and they testified that they would not likely be able to drill these wells if the applicant were not approved. So that would meet the test of protecting relative rights and preventing confiscation. Shockingly, in my view, the ALJ at the commission denied the application, and the basis for that, even though it wasn't contested and 99% of the unit was supportive of drilling this, they claimed that the Railroad Commission did not have the authority to reverse pool. And basically what that means is that historically people have felt that a proper pooling was a owner that had been excluded from the unit because maybe they were 467 or 330 feet away from the well to pool into some of the larger tract owners' wells. Basically, they were going to be excluded and their minerals not produced, so they had the right to pool into the unit. What was happening here was the larger owner, in order to get the well drilled, was trying to pool the small owner into their unit. And the ALJ said that's no authority for that. And they also didn't believe Finley when they said that it was necessary to drill the well. Well, thank goodness the Railroad Commission reversed that and said, no, there's no distinction between reverse pooling or forward pooling, whatever you want to call it. Statute doesn't make that distinction. And even though we may have not seen this very often, clearly we have the jurisdiction to do it. And so they went ahead and they pooled these unleased tracts. But here's the kicker. I think either misreading the statute or trying to send a message that they just don't want these coming to them. They gave the unleased tract owners a fifth royalty. Now, there was no cash, but a fifth royalty, and instead of assessing a risk fee, they said that you would back in at a zero risk penalty. So the unleased owners were not only getting the highest royalty paid in the field, but they were also backing in as a co-tenant 100% payout, which is much better than any other offer that had been given in the field. So in this case, the Railroad Commission said, essentially, we're going to give these people, even though they're not actively protesting, we're going to give them a better deal than anybody else in this unit has gotten because they haven't agreed with you voluntarily. This is what that unit looked like. And the surface location was this big white tract here, which was a abandoned Best Buy that we bought and tore down to get a big enough tract in the middle of Fort Worth to be able to drill a well. Drilled it directionally, drilled it through this housing addition, and those colored boxes are either the ones who did not respond or the ones that refused to sign. So you can see, without pooling or without a Rule 37 exception, that well could not be drilled. Okay, well, compare that to Oklahoma. In Oklahoma, we would have just built a 640-acre unit, got a drilling spacing order, and just moved on, because then all those owners would be deemed to have been unitized, and at worst, we could carry them and drill the well legally, but then they would just back in at 100% payout. So in a sense, Oklahoma's spacing and pooling laws are much more pro-development, at least in a scenario like this, than Texas are, which make it really, really hard to drill a well like that in that type of an area. All right, let me talk about multi-section horizontal wells. This is kind of the update portion of this talk, because this is the new laws. Oklahoma enacted in 2011 what they call the Shale Reservoir Development Act, and it gave operators two options to drill a well across a unit boundary, across a section boundary. Remember what I said earlier is historically we could drill horizontal wells, but they were limited to the confines of a 640-acre unit, so our lateral length was limited. Here now we can drill in shales, or at that point in shale reservoirs, wells that can cross a section boundary, and you can do it one of two ways. You can up front ask the commission to establish a 1,280 acre up to as large as 2,460 acre unit, which comprises multiple sections, and that's essentially a drilling and spacing unit. And then and you can drill your wells, across the unit boundaries however you want. It's basically you've eliminated those section boundaries. To do that, though, you have to get 63% of the working and royalty owners' approval, and you've got to submit a plan of development. Basically, you have to tell the commission why you should have a unit that big. They do not want you to come in and say, I'm going to drill one well and not have any plans to drill further, because in that event, why do you need such a big unit other than to hold acreage? So that has not historically been used very often, because nobody really wants to commit to a plan of development that may be in place for years. And if you can't comply with that plan of development, what's the penalty going to be? You know, what happens if you have rig availability problems or oil prices drop to $20 a barrel? Nobody wants to commit to a long-term development plan just to get a bigger unit, especially when option 2 is that you can drill a multi-unit horizontal well, which means you have 2 separate drilling and spacing units, and you have the authority to cross across that boundary. And the way that works, you don't have to have a percentage approval. You get an interim order that authorizes you to violate that boundary restriction to let you drill your well. At that time, you estimate what the length of the lateral will be, and so you estimate the relative cost and revenue distribution. You drill the well, then you go back and get a final order, and then that finalizes the apportionment of the cost and revenue. It's a fairly seamless process, has been anyway. Then in 2017, Oklahoma enacted the 2017 Energy Jobs Act, interesting name, but essentially extended the Shale Act provisions to all geological formations, basically changed one word from shale to targeted, so now all targeted geological formations are governed. It went in and changed the statutory cap on units from 640 to 1280, assuming you have a projected lateral greater than 7,500 feet. And then if you want your first well in a multi-unit scenario to be the initial well, then you've got to have a longer lateral because otherwise you're holding 2 units, and they want to make sure that there's ample coverage of both of those sections. One interesting issue that's come up already since then is this concept of associated common sources of supply. In Oklahoma, it's always been the practice to pool all zones, including and down to your target zone. And in a vertical well, it makes sense because you can say, well, if I'm drilling and I get a big kick in a zone, above the zone I'm targeting, I might want to stop drilling right there, and I don't want to have to go back and pool after I've already drilled a well. So the commission gives you some flexibility on that. Of course, when you're drilling a horizontal well, that's not really possible. So, but people have that culture exists, and so people have continued to try to pool all these zones to hold them with the drilling of a horizontal well that clearly is not draining those zones and is not impacted by that well. So the commission has, in the statute now says that you can pool adjoining common sources of supply to your target zone with the thought that as you're drilling, you might inadvertently encounter one of those zones, and therefore that production will be deemed to be coming from the target zone, and therefore the elections under your pooling order will be binding with respect to that zone as well. And so before the 2017 Act was encountered, we had this dilemma where one of the operators had pooled multiple zones and multiple productive zones that could be exploited with horizontal drilling, but had only drilled the deepest horizontal leg. And they were holding the adjacent reservoirs, and were actually, asserting that they own these reserves and their PUDs of their public filings. And Fairfield filed an objection saying, "You've drilled your well, you didn't touch these zones, and you're holding them, and these should be dropped." And that would dramatically reduce the reserves that company was holding. And they, as you would expect, opposed that and said, well, we plan to go back and drill those wells, and we might inadvertently drill through those zones when we drill our 3rd, 4th, and 5th wells, and so we ought to be able to keep that until we finished our full development plan. And the commission said, no, that we're going to make you dismiss, after you drilled your first well, all the other zones that you pooled, unless you can show that in that initial well you inadvertently encountered one of these adjacent zones. And that concept was, basically I've explained why they did it, but it was, you can, if you have a plan of development, they also said if you do have a plan of development that you intend to drill those other zones, we won't make you dismiss those zones from your pooling, but effectively it comes to the same result because we're going to make you give those people new elections. So they effectively treat it as 2 different poolings. But as I said, this had a dramatic impact on people's reserve reports where they were claiming to have behind pipe reserves when in fact they didn't because they lost it for not developing it timely. Another concept that's come up in Oklahoma, as I said earlier, is concurrent development. You've probably read about some of the disputes between horizontal and vertical operators in Oklahoma because you have existing vertical production, some of it fairly marginal, and a lot of these companies who are vertical operators have additional locations they want to drill. In fact, they may have bank debt tied to these additional locations. But there's a clear preference for horizontal drilling. As Jason said, you know, when 88% of all the new wells in this country are horizontal, they obviously carry a big stick. And so the commission has tried, in Oklahoma, has tried to accommodate concurrent development by allowing existing vertical spacing to continue, and those operators can continue to try to develop their resource under a vertical spacing and then try to deal on a case-by-case basis when you have conflicts with horizontal drillers who are wanting to drill across potential locations of the vertical wells and vice versa. And one of the consequences of this is what's been called well bashing, and that is disputes that arise when you have these inherent conflicts between vertical and horizontal drillers. We've had several lawsuits that have been filed now where people who have vertical wells claim that they have been bashed by the frac operations of these horizontal wells that come dramatically close to their wells. And then the horizontal operators say, well, your well was marginal, so you had minimal damage, or even, you're going to ultimately recover more oil and gas because of my frac. So there's a lot of he said, she said type expert witness testimony in these things. And so far, it hasn't really been cost effective to bring these suits. I think Devon had one, and after $1 million of attorney's fees spent on both sides, the party suing Devon got $200,000, so it wasn't cost effective for them. The fear, though, is that in Oklahoma, if you have damage to property, that entitles you to attorney's fees. So in that case, that company may end up getting their fees. And it is a tort, and therefore you're potentially liable for punitive damages. So my concern is that someday somebody's going to get popped by a jury, and it's going to be a multi-million-dollar case dealing with a relatively minor damage model because a lot of these wells really aren't that productive. And my view as a possible resolution is to have some type of appraisal and condemnation process where if somebody wants to drill a horizontal well and it's going to impact your well, have some type of appraisal process where they have to pay for that in advance. And what we're seeing is a lot of agreements where that's exactly happening. It's just not being mandated by law. All right, this again to kind of remind you of what we're talking about. This would be a perfect example of a potential well bash where that horizontal well is coming close to the vertical well. Okay, let's talk about Texas multi-unit wells. Basically, two ways to do this in Texas too. Texas will approve a permit of an operator if he has 65% of the working interest and 65% of the royalty owner's approval. There's no real rule on this. It's just been their policy. They could, depending on popular views, they may decide that 65 is too much. They may decide that it's too little, but that's their process now. All you have to do is represent that in your permit. You don't have to show them your agreement, but the way this is accomplished is that you have a production sharing agreement, which is a formal agreement on how you're going to share production cost and expense and revenue as between the two units, usually based on the length of lateral, perforated lateral that's in between the two units. You have to have one of these for every well, even though you're going to have potentially multiple cross-unit wells. I can tell you from a landman's perspective, it's a whole lot of work to get these things. Even though it may be advantageous for the royalty owners, a lot of times they want some compensation for that. If you're a working interest owner and you just have a JOA that covers that unit, then you got to amend the contract area to provide for that. So it's a lot of work. And if you don't get 100% approval, and it's an owner that's within 330 feet, you're going to risk potential Real 37 issues again. And again, the Real 37 requires notice. You may not get it approved. Most leases don't contemplate cross-unit wells. They allow you to pool a unit. It doesn't talk about amending units. A lot of times your unit declaration does not allow you to amend your unit without 100% consent. So it's, and then you've got an issue about what happens if you do drill a well, even though the commission authorized it. Can a disgruntled owner go back to the commission and say, you shouldn't have granted that order because I should have been given notice and an opportunity to object? And then whose burden of proof is it to prove damages? Is it the operator's duty to prove there was no drainage? Or is it the royalty owner's or disgruntled parties' burden to show that they somehow are losing production through this process? So it creates a lot of minefields. The second option in Texas is to do an allocated well permit, which all you have to do is represent that you, as operator, own 100% of the leasehold in the 2 units. And the view is that in that event, no notice is given to the royalty owners because they're represented by the lessee. The lessee is supposed to look out for them. If there's a dispute, the commission says that's between you and your royalty owners. I will say this issue is eroding a little bit. People are starting to protest allocation wells. Royalty owners are saying that, I might have a higher royalty in one unit than the other, and I should have been given notice. The operator's not adequately protecting my rights. So I'm not sure where this is going, but kind of the moral of this is that Texas largely leaves allocation wells to private agreements still. They haven't really gotten involved in these nuances. All right, I'm just going to give you side-by-side comparisons of the things we talked about. In Oklahoma, once you form a governmental unit, there is no concept of trespass. You can drill a well anywhere in that unit. You can even drill on somebody's land that you don't have a lease on. Under the Oklahoma Surface Damage Act, if you have a right to drill in that unit, which means you have a lease anywhere in that unit or own a mineral interest in that unit, you can essentially condemn somebody's property in order to get a surface location. In Texas, not only can you not drill on somebody's property, but despite creating a unit, well, first of all, you cannot create a unit if you have an owner who's within 330 feet of your proposed well bore. You can't drill your well without their consent. And in any event, you couldn't use their property as a location. I will say this 330-foot setback, I like to characterize that as the prince and pauper scenario. If your tract is within the minimum setback, you are the prince. You absolutely control all the leverage. If your tract is 1 foot away from that 330 feet, you have no leverage, and you can be excluded from that well and really have no rights unless you want to bring a forced pooling proceeding. And as I've told you, that's really complicated and difficult. So a landman's nightmare is to drill a well and think there was a tract that was 400 feet from the wellbore, and it turns out it's 250 feet, and it changes everything. And as far as production sharing, again, once a government unit is formed, all the tracts in that unit share in production regardless of where the well is, whether you have a lease with that interest, whether you have a contract. It is essentially communitization of the lands for the purpose of sharing in production. In Texas, again, if you have a tract that is outside of that minimum setback, they may not share in production. You, as an operator, have no duty to enter into any agreement with them and add them into your well. Alternatively, if they are within that minimum setback, you can't drill your well without that owner's consent. Now, I will say that with horizontal drilling and multi-well pads, it would be foolish not to negotiate with everybody in the unit, because even though you might be able to drill well 1 without getting too close to that unit boundary, if you want to fully develop that unit and have 6 or 8 wells, you will inevitably have to go back to that party who you've excluded from your unit and say, well, I want you in my unit now. So always a good idea to get 100% of that unit locked up. Unit size and shape. In Oklahoma, units are of uniform size and shape. They range from 10 acres to 2560. In Texas, the unit size and shape is largely discretionary so long as the minimum setbacks and your individual lease terms are honored. I've seen some really wonky units in my day. And one problem in Texas that does not exist in Oklahoma is you can have stranded acreage in Texas. There may be a tract that does not happen to fit within people's units. And in Oklahoma, rarely ever happens because the units all fit together as a nice puzzle, and everybody's guaranteed to share in production. Off-pattern wells in Oklahoma, the location exceptions are routinely granted with minimal penalties. I mentioned the mirror offset concessions. Even if you potentially are going to well bash. I've been involved in disputes, protests at the commission where a vertical operator objected to a location exception, said this well is coming within 100 feet of my well bore, and shockingly the commission granted it, and it ended up bashing the well. So Oklahoma is very lenient about off-pattern wells. In Texas, off-pattern wells are rarely granted, and non-compliant wells can be shut in or even plugged. And pooling in Oklahoma, we have forced pooling. It's essentially an eminent domain proceeding. You can be compelled to participate and put your money up front, or you can sell or lease your property at a fair market value depending on what testimony is at the hearing. There is no option in Oklahoma to be carried if you're pooled. You either put your money up front or you give up your interest under one of these scenarios. In Texas, again, forced pooling, very rare, and as we saw in the Finley case, even when it does happen, it can result in greater than fair market terms than what's been paid to other parties. And then lastly, cross-unit wells in Oklahoma, starting to happen all the time. It's largely administrative. It happens under 2 ways, the multi-section unit or the multi-section well. And largely now it's that multi-unit well, multi-section well for the reasons I said. And in Texas, you can do it, but it's largely left to private agreement and either under the allocation well route or under the Production Sharing Act or manner. So I have one question for the group. What other application can you think of where conservation laws might be appropriate? Anybody have any ideas? Well, how about that? So this, in my view, is not much different than the first slide I showed you, the rural capture in the oil and gas business back in the 1930s. You have a situation where while a lot of people get leases ahead of time, once the location for that turbine is determined, it's 5 or 10 acres, only the owners of that surface share in the revenue from that particular turbine. Well, the people surrounding that turbine have to live with it. They potentially hear the noise. They have the dead birds in their property. It impacts the value of their property. So my view is that we should get to a point where we're starting to unitize wind and have more people share in the revenue, since the whole community is bearing the cost and the detriment. And then I want to leave you with one last thought, and that is historically the commissions have focused on the quantitative regulation of oil and gas. How many wells are we going to drill? Where are they going to be located? And how are we going to maximize production from the resource? My view is that we're getting into a situation where the commissions should also think about qualitative regulation. As an example, particularly in a time of plenty where we seem to have adequate resources, but it is still a finite resource that at some point is gone. Should the commission not be focusing on relative value of wells? As an example, the Mississippi Lime of northwest Oklahoma are essentially water wells that produce a small amount of oil. Is that the type of well that we should be permitting if there are alternatives that produce more oil relative to their byproducts, cost less money, have less risk on the environment, and are generally, the lower hanging fruit? And just throw that out there to you. I think that is within these commissions' jurisdiction. Another one would be drilling in the inner city of Fort Worth. My company did it, but is that the best place to be drilling wells? Is that going to have the highest impact environmentally on people? Should we not be focusing on drilling in areas that have less environmental impact? So, just someday that may be a political issue that one of these commissioners decides they want to take on. All right, that's all I have.
We have a situation where they've drilled a horizontal in a section where there are probably a dozen, I think there's 13 actually, vertical wells. Will that be considered bashing? It's the same company that drilled the horizontal that has the lease, but they went to a different zone.
Well, it might be, but you wonder who cares, because if the royalty owners are the same and all the working interest owners are the same, the operator has chosen to use modern technology to maximize recovery. So you really don't have a well bashing problem unless you have divergent ownership, and that's what you're seeing a lot of, because under pew clauses, a lot of times your former leases have now been limited to the producing interval of that in that well, and so you don't but you could. I mean, somebody, here's a scenario I see all the time. You've got a vertical well operator who just doesn't have the money or the risk appetite to drill horizontal wells, and so when they get a proposal, they may farm it out or just elect not to participate, and so it's the same zone, but now you have divergent ownership, and so that vertical well operator has a legitimate reason to want to protect his investment. So it's an issue. I mean, horizontal wells, when you're talking about drilling multiple wells from a common pad, you could have 12 to 16 wells in a unit, and if you've got vertical production, it's hard to believe that you're not going to have some impact on that. These fracs are enormous, and I've seen a lot of problems. Now, it raises this issue. I mean, it's not a lot of money. These wells are typically not making a lot of production, but if you're a small operator, you might be getting $1,000 a month in operating overhead, keeping this well going. And so if you lose that, adds to your damages. So really there should be, and I'll point this out, in West Virginia, interestingly, the mineral estate is dominant to the surface estate, like most states. But the coal estate is dominant to the gas estate. And so if you drill a gas well in West Virginia, you have to notify the coal owner, and they have a right to protest your well, claiming that that's in my open mine path, and therefore I don't want that well to be drilled. Or you can drill your well, but then the coal owner has the right to buy your well for fair market value if and when they get there. And so that's a good analogy. If a horizontal well operator wants to impact a vertical well, there ought to be a process where without juries and without potential punitive damage scenario, to be able to get 3 appraisers to come in and appraise the value of that well, and say, if you as a horizontal driller want to drill that, you can, but you're going to have to buy that well, and you can decide what you want to do with it. So I'm really in favor of that resolution, because it's always better to eliminate the uncertainty